Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. Continuing with our endeavor to study the proceedings under the Insolvency and Bankruptcy Code 2016, I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements under the Act IBC 2016. So let us today collectively study an important judicial pronouncement under this Act. So this is the case of State Bank of India and others versus Rajesh Agarwal and others. It was decided on the 27th of March 2023 by the Honorable Supreme Court of India. On 27th of March 2023, a two-judge bench of the Honorable Supreme Court of India in a group of matters titled State Bank of India and others versus Rajesh Agarwal and others, inter alia upheld the decision of the Telangana High Court in Rajesh Agarwal versus Reserve Bank of India and others. The High Court held that the principles of audi alterum partem, which means let the other side be heard as well, must be read into the provisions of the clauses 8.9.4 and 8.9.5 of the Master Directions on Fraud, dated 1st of July 2016, updated on 3rd of July 2017, which were issued by the Reserve Bank of India in order to grant a borrower a right of hearing before its accounts are classified as fraudulent by banks and financial institutions. Let us see the factual background of the case. BS Limited is a company engaged in the business of power transmission and distribution, passive telecom infrastructure, renewable energy, and mineral resources. It availed loans amounting to rupees 1,406 crores from various banks. The company failed to meet its payment obligations to lender banks, thereby defaulting in repayment of credit facilities. In accordance with the Master Directions on Frauds, all the lender banks formed a joint lenders forum with State Bank of India as the lead bank. The JLF declared the company's assets as non-performing assets on 29th of August 2016. The lender banks decided to adopt the Sustainable Structuring of Stressed Assets scheme and suggested a forensic audit report and techno-economic viability study in its meeting held on 11th of July 2016. Based on the conclusions of the forensic audit report, the JLF closed the issue, stating that there were no irregularities. However, based on the TEV study, it was concluded that the company was not eligible for the S4A scheme and requested it to submit an alternative plan for regularization of its account. In the meanwhile, IDBI Bank, one of the lender banks, red flagged the account of the company. Additionally, proceedings under the Insolvency and Bankruptcy Code 2016 were also initiated against the company. On 15th of February 2019, the JLF declared the account of the company as fraud by invoking clause 2.2.1G of the Master Directions on Frauds. Subsequently, the Fraud Identification Committee passed a resolution on 31st of July 2019, identifying the company's account as fraud. The company filed a writ petition challenging both the decision of the JLF dated 15th of February 2019 and the resolution of the Fraud Identification Committee dated 31st of July 2019 before the Honorable High Court of Telangana. By a judgment dated 10th of December 2020, a division bench of the High Court allowed the writ petition by holding that the principle of audi alterum partem ought to be read into the clauses of the Master Directions on Frauds. The High Court further directed the lender banks to give an opportunity of a hearing to the borrowers after furnishing a copy of the forensic audit report and to provide an opportunity of a personal hearing to the borrower before classifying their account as fraud. The judgment of the Honorable High Court was challenged on 15th of April 2021 before the Honorable Supreme Court of India. This court, while issuing notice, partially stayed the directions issued by the Telangana High Court. Now let us see the findings in the rationale. The Joint Lenders Forum and the Fraud Identification Committee had classified the account of the company as fraudulent on 15th of February 2019 and 31st of July 2019 respectively. It was the petitioner's case that the same was done without granting the company a hearing. It was contended that the said classification attracted both civil and criminal consequences upon the company, as well as its promoters and directors, such as declaring them as ineligible to avail financial loans and assistance from financial institutions, and rendered them liable for criminal prosecution by law enforcement agencies. Hence, the position that there was no requirement of hearing a borrower prior to classifying its account as fraudulent under the master directions amounted to a denial of the principles of natural justice, as well as a violation of the borrower's fundamental rights under Article 19(1)(g) of the Constitution of India. It was further contended by the petitioner that the same was also a violation of Article 14 of the Constitution, inasmuch as the lack of natural justice in the master directions provided the JLF and the Fraud Identification Committee to take a decision with unbridled powers without giving an opportunity of hearing to the borrower. The petitioner relied upon SBI versus Jaha Developers Private Limited, where the Honorable Supreme Court had held that a prior hearing was required to be given to a borrower prior to classifying a borrower's account as a willful defaulter under the relevant RBI Master Circular. Now let us say what are the observations of the court. Acceding to the above contentions, the Telangana High Court relied upon SBI versus Jaha Developers and a catena of other judgments relating to the principles of natural justice, and held that considering the drastic consequences faced by a borrower, as well as its directors and promoters upon its accounts being classified as fraudulent, it was imperative that the principles of audi alterum partem be read into the master directions so as to ensure the passing of reasoned orders, which will ensure that the same are not arbitrary and do not violate the fundamental rights of a borrower. Accordingly, a borrower whose accounts are classified as fraudulent under the master directions must be given an opportunity to be heard before its accounts are classified as fraudulent. On this basis, the decisions of the JLF and the Fraud Identification Committee were set aside by the Telangana High Court as being arbitrary and in violation of the principles of natural justice. Now let us see the decision of the Honorable Supreme Court of India. The State Bank of India, the lead bank forming part of the JLF consortium, had filed an appeal before the Honorable Supreme Court from the judgment of the Telangana High Court, which was dismissed by way of the present judgment. The crux of the reasoning adopted by the Supreme Court is that the action taken by the banks have criminal ramifications as well as grave civil ramifications, as the borrowers or its directors cannot avail credit facilities which amounted to blacklisting. Further, since the said action is an administrative action, the principles of natural justice must be incorporated into the master directions. Thus, the Honorable Supreme Court held that the principles of natural justice be read into the master directions, and further held that a reasoned order be passed by the banks and the JLF after granting an opportunity to a borrower to present its case as to why its accounts should not be declared fraudulent. So we conclude that the judgment will be of a solace to the companies undergoing debt restructuring, as the process of classification of loan accounts as fraudulent will not take place in a mechanical manner, and a borrower will have a right to be heard. Even if the banks or the financial institutions were to classify a company's accounts as fraudulent, the same will only be done after the concerned borrower has an opportunity of presenting its case and explaining any circumstances in its favor, which will bring a modicum of fairness to the entire procedure. In the absence of this, there is tremendous potential for arbitrary blacklisting of the companies or their directors from accessing institutional finance, while also simultaneously facing criminal proceedings without even being given an opportunity of being heard, which entails significant reputational, legal, and financial risks and consequences. The emphasis by the Honorable Supreme Court on a borrower's fundamental rights and reiteration of the incorporation of the principles of natural justice in the master directions is a welcome development in the jurisprudence surrounding this area of law. So, friends, we conclude that the Honorable Court has protected the rights of the promoters and directors and also protected the principles of natural justice. So, friends, I hope that you find this both enlightening as well as engaging. And to get further insights into such judgments, please like this video and subscribe to my YouTube channel. So thank you, friends, for being with me here today. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.